Your Lordships may be begin. Good
Good
morning.
morning, brother.
Good morning. First of all, I would like to congratulate both the teams on qualifying to the semi-finals. Today, we have the bench comprising of Honorable Mr. Justice Abhay Ittigi, Honorable Mr. Justice Gangadhar Hoskeri, and Honorable Mr. Justice Rohit Kamath. I would request the judges to kindly verify the team appearing before the bench. Team 11 is appearing on behalf of the applicant, and team 26 is appearing on behalf of the respondent. If your lordships may kindly permit, we may start the proceedings.
Yes.
Much obliged, your lordships. The applicants may start.
Counsel seeks permission to approach the bench
How will you approach?
through an online platform.
Comments.
Much obliged. The counsel seeks permission to address the bench as Your Excellencies.
Very good.
Much obliged. Your Excellencies, in Union of Remraf versus Republic of Wales, Kingdom of Retav and Tistadelphia, that is the case concerning the accident on River Egrel. This is agent number 1 on behalf of applicants, and the present counsel shall be taking 15 minutes of court's valuable time, and the counsel shall be taking 13 minutes of the court's valuable time, and 2 minutes have been respectfully saved for rebuttals. The counsel seeks permission to summarize the facts of the case.
Yes, very briefly.
Much obliged. Your Excellencies, Ria is the capital city of Wales, situated at the banks of River Egrel, one of the largest rivers in the world, whose distributaries run all across the country and thereafter flows to downstream countries such as Republic of Remraf, city-state Tistadelphia, including Kingdom of Retav. Kingdom of Retav, under the vision of Prince Mustafa Albeko and under the monarchy of King Mustafa Nagbeku, incorporated Retav Inland Waterways Fail Incorporation, hereafter referred to as RIWF, in accordance with the Fail Incorporation laws, with the head office of the company at Ria. On 24 January 2021, 3 vessels owned by the Retav Inland Waterways were hired by Tistadelphia for carriage of weapons of war, civil explosives, and oil from Ria to Tistadelphia. As it was the season of monsoons, due precautions were taken to ensure the seaworthiness of the ships, and the authorities allowed for the commencement of the journey. The ship started their journey on 25th January 2021 and were due to enter into the borders of Union of Remraf. And on account of bad weather, the radar and communication channels of the vessels were exposed to rain fade. Meanwhile, in the early hours of 26 January 2021, a red alert was issued by the Union of Remraf of the possibility of a hurricane and heavy thunderstorms in River Egrel. Unaware, the 3 vessels continued their voyage. With about 38 nautical miles to enter into Remraf, 2 vessels collided with one another, leading to a spillage of oil into the River Egrel. One event leading to the other, with a strike of lightning, all 3 vessels ignited and exploded, leaving a long trail of fire carrying all the debris, high in ammonium nitrate, downstream to Union of Remraf, which was purely an agrarian economy engaged in agriculture and dairy farming. River Egrel being the chief source of drinking water for all 4 countries, the accident cost all of them dearly. Over 15,000 people from Fail and Remraf consumed the water and died on account of severe methemoglobinemia. Retav Inland Waterways Fail Incorporation filed for bankruptcy. Union of Remraf, aggrieved by the loss caused they to negotiate with the others to approach the International Court of Justice for relief since the negotiation talks failed. The council seeks permission to proceed with the arguments.
Yes.
Much obliged. Here, the first issue being that the Republic of Fail is liable for the accident on River Egral. It is humbly submitted before the Honorable Court.
No, agent, before you commence on merit, could you address your reliance on Article 36(2) of Statute of ICJ?
Indeed.
Counsel, what my brother judge is asking is, can you justify how this court gets its jurisdiction?
Pardon?
You have relied on Article 36(2) of Statute of ICJ. Can you tell me on what basis do you rely on it?
Your Excellency, Article 36 Clause 2 states that the states parties to the present statute may at any time declare that they recognize as compulsory ipso facto and without special agreement in relation to any other state accepting the same obligation, the jurisdiction.
No, just 1 minute. We know the text of Article 36(2), but in this case, there is a special agreement, isn't it?
Indeed.
Then should it not fall under Article 36(1) rather than 36(2)? Because 36(2) applies if there is no special agreement.
Your Excellencies, as per the statement of jurisdictions as provided in the written submissions, the councils are approaching the Honorable Court as per Article 36 Clause 1. It's given in the written submissions.
Statement of jurisdiction. Please see your statement of jurisdiction.
Pardon me, can you repeat? Your voice is breaking.
Please see your statement of jurisdiction on
Indeed.
page 6. Page 6 of your written submissions. Am I audible to you?
The applicant and the respondents have the honor to submit the following dispute to the ICJ by special agreement for...
See the last line of your statement of jurisdiction on page 6, please.
In accordance with Article 36 Clause 1 of the ICJ statute, each party will accept the judgment of the court as final and binding.
36(2) you have written.
No, Your Lord. No, Your Excellency.
Are you sure?
If Your Excellencies may permit, I can share the screen and show the same.
Just 1 second. Just 1 second. Just give me 1 minute.
We have received it as 36(1). Brother judge is right.
But the council is contending that we've approached to 36(1).
1 second. Just give me a minute. Just give me 1 minute.
Indeed.
Court officer, you have sent us some other written submissions. Brother Gangadhar, please check your email. Rohit, you can also check.
Yes.
The team codes are different.
There are two emails. One is 11 and 27.
Oh, 1 second.
Your Lordships, it will be rectified and we'll send it again.
No, 1 second. No, my bad. Rohit is right. 1 second.
Yes.
I'm so sorry. Just...
I think these are all on account of virtual hearings that's going about. So I believe there are multiple case files that have reached the bench.
Crazy.
Your Excellencies, can the council please request the time be paused right now?
Yeah, that we'll take care of. Just wait for a minute.
Much obliged.
Yeah, go ahead.
The council seeks permission to proceed with the arguments.
Yes, please.
Much obliged to Your Excellencies. Your Excellency, here the first issue is that the Republic of Fail is liable for the accident on River Egral. It is humbly submitted before the Honorable Court that the Republic of Fail must be held liable for the accident on River Egral. The Republic of Fail had a responsibility to ensure that the ships were well equipped and competent enough for voyage and must have taken precautionary measures in order to ensure safe voyage, especially considering the hazardous nature of the carriage in the ship. The negligence of Fail in this regard has cost thousands of lives. has been detrimental to the environment and in gross violation of several international laws and conventions. Here, the first subcontention being that the force majeure clause cannot be invoked. Your Excellency's force majeure or act of God has been defined lato sensu as an unforeseen or foreseen but inevitable or irresistible event external to the obliger, which makes it impossible for him to perform the obligation concerned. A series of primary rules of international law is specifically intended to regulate events of or occurrences due wholly or partly to force majeure. If the alien has been injured outside the territorial jurisdiction of the state, the latter is generally regarded as incurring international responsibility for its action instantly, namely without the alien having to exhaust local remedies.
One minute. Who is this alien in this case?
This is the general principle. This is the general principle laid down. The council is referring to the foreign country which entered the territories.
Which foreign country entered a territory in this case?
Your Excellencies, in the instant case, when the ships entered the international rivers, that is considered to be the foreign body which entered.
Foreign body entering international waters is called alien?
No, Your Excellency. The council is coming to that. The council was just laying down the principle.
Yes.
Much obliged. Your Excellency, in the instant case, Republic of Wales failed to take all the necessary precautions to prevent the damage caused or even reduce the magnitude of the accident, owing to which force majeure cannot be invoked. In order to exonerate a state from its responsibility, force majeure must possess the three traditional characteristics stated in all legal systems: that it must be irresistible, it must be unforeseeable, and it must be external to the party invoking it. The expression force majeure does not appear either in the International Covenant on Economic, Social, and Cultural Rights or in the Covenant on Civil and Political Rights. Further, in the Corfu Channel case, that is United Kingdom versus Albania, the court reached the conclusion that Albania was responsible under international law for the explosions which occurred on 22nd October in Albanian waters and for the damage and loss of human life which resulted from them, and there is a duty upon Albania to pay compensation to the United Kingdom. Further, in the case concerning rights of...
One minute. In the Corfu Channel case, did Albania pay?
It has not yet been executed, but this is the order that has been passed by ICJ.
Would you be satisfied with a paper order from us?
No, Your Excellencies. But however, to determine the liability of the other countries, it is important to place our reliance on this particular case.
Yes.
The Council seeks permission to proceed?
Yes.
Much obliged. Further, in the case concerning rights of nationals of the United States of America in Morocco, that is France versus the United States of America, again, the three principles that the council stated earlier have been laid down.
Yeah, so according to you, force majeure cannot be invoked.
Indeed.
If force majeure cannot be invoked, according to you, what caused the accident?
Your Excellencies, in the instant case, the accident and the effect of accident was an effect of the negligence of fail, which failed to take all the due considerations which were necessary considering the circumstances and the weather.
So according to you, what was the precautionary measures, as you call it, that file had to take? Because as we read the fact sheet, they only inspected the ship for the seaworthiness.
Indeed.
Which they are bound to do.
Indeed. Your Excellency, the council agrees to what Your Excellency is saying. However, we have to make note of the situation at hand, because this was an extraordinary situation which should have been forecasted considering that it was monsoon season. The ships were probably...
What should be forecasted? What?
The hurricane and the heavy thunderstorm, considering it was monsoon season.
Because they did not forecast it, force majeure cannot be invoked. That's what you're saying.
Council, as the word goes, forecast, it can go right, it can go wrong. So it is near prediction. So it is not something that is completely, that cannot be questioned at all. So it is nearly a prediction. What if the monsoon does not happen or occur?
Indeed. Your Excellency, Of course, there is a chance. It's the whole point is that it's unpredictable. However, that is not an excuse for negligence. Even if it doesn't happen, they had to be prepared in case it happened, considering the magnitude of accident that would cause in case it happens.
Counsel, I take your statement as admission here. So you mentioned that it is unpredictable. So if something is unpredictable, how can I be prepared for it? I take that as an admission.
Your Excellency, by unpredictable, what the council meant is that once it has been forecasted, whether it actually occurs or not is beyond the control. However, in case the event occurs, they have to be prepared for the same.
No, it was beyond the control. Council, it was
Indeed.
beyond control. Act
Indeed.
of God. So the incident has taken place. As rightly
Indeed.
pointed by my brother, so it is unpredictable, beyond the control, act of
Indeed.
God. So,
Your Excellency, here what we have to take note is that for force measure to be to invoke force measure clause, another major part is that we have to recognize that it must be completely unforeseeable. It cannot be forecasted or predicted. As
Counsel,
laid down.
Let me give you a small identification. Probably you're not able to align yourself. When was the date on which the red alert was issued?
Or 25th of January.
Please check your fact sheet.
Or 26th, I believe.
Yeah, when was the date on which the seaworthiness or the travel started?
Or 25th.
So how are you able to say that I should have forecasted?
Indeed.
So probably REMRAF should have given this notification on 23rd. Probably the circumstances would have been different.
That's right.
Indeed. Your Excellency, even if we are to consider that abarguendo, when we look at fact sheet para 3 and 4, we can see that the communications failed due to rain fade. And this was another major negligence on part of the authorities, because they had to know that this was the season of monsoons, which is clearly given in the fact sheet. So it being the season of monsoons, the probability of it raining heavily was extremely high. And despite that, they did not take sufficient measures to ensure that at least communication can be reached.
Okay.
And
so
that would be the
conclusion on this.
That force measure cannot be invoked.
Okay. Probably you need to convince us better.
Your Excellency, if the council make one more submission regarding the same, against the Germanic doctrine of reprisals based on collective responsibility for wrongs done to a state or its subjects by a foreign state or its subjects, Grotius introduced into international law the Roman law doctrine of responsibility as dependent on fault. Grotius started with the famous old principle of Roman law, that is ex tali culpa obligatio naturalizer oritur si damnum datum est, that is from such a subjective fault springs naturally an obligation if damage has resulted, which has clearly resulted in the instant case.
Counsel, I agree on the principle wholly, but tell me what is the fault here?
The fault is the negligence on part of the authorities.
What is the negligence?
What is the negligence?
Not ensuring that the ships were equipped enough, if not to handle the extraordinary circumstances.
Now let us assume that file authorities were negligent. Can you tell us, while the authorities inspected for seaworthiness, what all aspects they have to consider under the accepted norms of international law? Whether they have to check the weather of the region or the seaworthiness of the ship, because their exposure is limited to seaworthiness of the ship.
Indeed. Your Excellency, here we should also consider the nature of the goods being carried in the ships.
I'm not on fact, I'm on law.
Huh.
Under law, applicable international law, can you tell me what are the things that are to be inspected to confirm the seaworthiness of a ship?
As per general norms, the council seeks an extension of time.
Yes, sir.
Much obliged. Your Excellency, as per the general norms of laws, the authorities have to ensure that overall the ship is worthy for a voyage and it is capable of.
Correct, and not the weather conditions.
Your Excellency, by an extension, it has to ensure that the ship is
Under which law, agent? Under which law?
Uh, uh, Your Excellency, the Council seeks permission to proceed with the second sub-contention, which deals with the international customary laws and obligations.
Very well.
Much obliged. Your Excellencies, the second sub-contention being that the Republic of Wales did not fulfill its international obligations, the right of equal access to permits the transboundary applicant to raise questions concerning the permissibility of the activity, appeal against the decisions of the court or the administrative authority, and seek measures necessary to prevent damage to the same extent and on the same terms as a legal entity of the state in which the activity is being carried on. Similarly, the transboundary victim could seek compensation for damage caused on terms no less favorable than the terms under which compensation is available in the state of origin. The principle is also reflected in Principle 10 of the Rio Declaration and in Principle 23 of the World Charter for Nature. It is also increasingly recognized in various national constitutional laws. The duty to prevent transboundary harm has even attained the status of customary international law relating to environment. In accordance with the principle of sic utero tuo at alienum non latus, or as it is commonly called, the principle of good neighborliness, it is a well-established custom of international environmental law that no state has the right to use or permit the use of its territory in such a manner as to cause injury to the territory of another or the properties or person therein. It is well established that the obligations of a state to prevent transboundary harm is one of due diligence or best effort obligations, which requires all states to have taken all reasonable or necessary measures to prevent a given event from occurring. Due diligence is the standard basis for environmental protection and is also expounded in the widely supporting ILC draft articles. In the instant case...
Now, agent, you are, this proposition you are seeking against fire? Against fire.
Indeed.
So file had the obligation to protect environment merely because they carried out the seaworthiness test of the ship. That's your proposition.
Indeed. And the company was incorporated in FAIL as well.
Okay. Go ahead.
Much obliged. In the instant case, the oil spill did not pollute and contaminate the water of a river shared by several countries, but also harmed millions of people whose lives and livelihood is dependent upon the water of the same river. Further, where the responsibility of the state is established, an obligation arises first to discontinue the wrongful conduct, second to offer guarantee of non-repetition, and third to make full reparation for the injury caused. Your Excellency's Article 4 of the International Convention on Civil Liability for Oil Pollution Damage 1992 states as follows: when an incident involving two or more ships occurs and pollution damage results therefrom, the owners of all the ships concerned, unless exonerated under Article 3, shall be jointly and severally liable for all such damage which is not reasonably separable. Further, international covenant.
Hold on. Agent, you are now attributing the actions of a corporate entity to file, isn't it?
Indeed.
Because it is registered there, correct?
Indeed.
So the corporate entity does not have any obligation. It is the state to look at.
Your Excellency, here in further subcontention, the council shall be pleading how each of the countries is responsible.
Council, what my brother judge is trying to put out is, unless you make the primary entity responsible, how can you make the secondary entity responsible under the ground of respondent superior? For respondent superior to be liable, liability should be imposed on the first entity. The first entity over here in question is not the Republic of Wales. Rather, it is
the corporate entity.
Yeah. So first establish the liability of the corporate entity, and then probably you could just move on to the liability of the state for the same.
Your Excellency, in the instant case, considering the damage and considering the various countries involved, ICJ has been approached to determine the liability of the country. And furthermore, this particular corporation has filed for bankruptcy because it is unable to bear everything. And therefore, by an extension, these countries are being held. Let
me simplify my query to you. You say that the company is liable.
The company was responsible.
It was responsible. Now, because the company went into bankruptcy, you are coming on to the state in which it was registered. show me any principle of customary international law or any convention where you can do this.
Your Excellency, as per the customary international laws or conventions, as a general rule, the state has a general responsibility to ensure.
Don't go to general rule. My learned brother judge is asking for a specific rule. Please tell us a point in law which actually gives us this proposition.
Indeed. Your Excellencies, for instance, the draft articles on prevention of transboundary harm from hazardous activities and Article 16 states that the state of origin shall develop contingency plans for responding to emergencies in cooperation where appropriate with the state likely to be affected and competent international organizations. Further, the same draft, Article 3 of the same draft also states that the state of origin shall take all appropriate measures to prevent significant transboundary harm or at any event to minimize the risk thereof. And therefore, the Republic of Fail being the country of origin, by virtue of these conventions, it has to be held accountable for its actions.
Now, see, you are moving on to another proposition. Earlier, you said because it is registered in file, file was responsible. Now you are saying because it is a country of origin that it is responsible.
Your Excellency, when we take a holistic view, all these come into consideration, and after all this, it even gave the green signal to go ahead for the ships. Even that played a role.
So it was registered in file, number one. Number two, it was a state of origin. Number three, it gave go ahead.
Indeed.
These three, because of these three elements, you want to fix the liability of file. Correct?
Indeed.
Anything else on file?
No, Your Excellency.
Okay. Now, if file completely responsible, go to the next entity of respond number 2.
Due to the paucity of time, the council seeks permission to quickly summarize the second contention. The co-council shall deal with the rest of the remainder of the second contention.
Doesn't matter. Then let the co-council, co-agents start.
Much obliged.
You can start. No issue. No difficulty.
The agent seeks permission to proceed with the submissions. Briefly summarize the submissions under the second sub-contention. The co-agent will be primarily dealing with the liability of Philadelphia, which is third contention. But since because of the paucity of time, the first agent was not able to put forth the submissions under RETA, the council will be briefly putting forth the submissions.
Yes.
Your Excellencies, the primary principle under which the Kingdom of Retav is being held liable here is the principle of the polluter's pay principle. This was first established in 1972 by the Organization of the Economic Cooperation and Development, and further it was ratified and further incorporated under...
Hold on. First, you have to tell us what is this polluter's pay principle?
The polluter's pay principle as
according to you.
Your Excellency, the agent was not able to hear the second query.
Okay. Am I audible now?
Yes, Your Excellency.
Okay. First, you have to tell us what is polluter's pay principle. Okay. Then you have to tell us who polluter.
Your Excellency, pardon, but again, your voice break when you were telling.
Who is the polluter?
Indeed, Your Excellency. Under Principle 16 of the RIO
These two you address first.
Indeed, Your Excellency. The polluter pay principle, as incorporated under Principle 16 of the RIO Declaration, states that the polluter should, in principle, bear the cost of the pollution, the cost of cleanup of the pollution. And in this case, the polluter is not a single entity. The polluter is a combination of the goods which were owned by Philadelphia, the vessels which were owned by the Kingdom of Retav, as well as the Fail Incorporation, which gave the green light, even though the vessels were not seaworthy and pristine. So the primary polluters will be Philadelphia, accompanied with the Kingdom of Retav.
Council, it is not established that the ships were not seaworthy, so probably I think we will not take that on record.
Your Excellency, for the preliminary inspections conducted by FAIL suggested that the ships were ready to take on the voyage during the season of monsoon. That is what the fact states under the paragraph 2. However, when we look at the paragraph 3, when we take a closer look, what the facts state is that the communications were disrupted not by the hurricane, but rather simply on account of bad weather. Now, in monsoon, it is expected that the weather is going to be rough. If a vessel which is going on a voyage during the monsoon is not going to be able to maintain its communications, the communication system, based simply on account of bad weather, then that vessel is not fit to go on a voyage. Now, regardless of this, the Kingdom of Fail gave a green signal, which is why the actions were negligent and they acted in a reckless manner. That is where the liability of the Kingdom of Fail arises. Even though it's not mentioned in the facts, it can be implied from the consequences of the action, Your Excellencies. Further, Your Excellencies, again, the principle 2 and principle 16 of the RIO declaration state that the polluters pay principle. And since the when we look at the incorporation of the RIWF, it was incorporated under the guidance of the finance minister, who is the brother of the monarch of the state. And the corporate will can be lifted in this instance as the promoter or the director, which can be assumed from the facts, is the entire state itself. It was not made by a private entity. But
now, hold on. Can you show me in any earlier instance to this whether this bench, that is International Court of Justice, has lifted the corporate veil?
Your Excellencies, again, in the trials Milter case, it was not the International Court of Justice, but rather the arbitration panel. It was the arbitration panel.
And that is not binding on us.
Indeed, Your Excellency. The agent will get back to an answer after conferring with the researcher. In the paucity of time, the agent will proceed with the third contention.
Very well.
The third issue being presented here is the liability of the Tistadelphia for the accident caused in the carriage of dangerous substances. Now, the facts clearly indicate that the transportation of the goods in question is weapons of war, civil explosives, and oil from Riyadh to Tistadelphia. Now, Your Lordships, the three arguments being put forth is that Tistadelphia failed to meet its international obligation. The Council will be combining the violation of human rights and the water pollution in the interest of time. And further, that the carriage was for the sole use and benefit of Tistadelphia. Hence, it did not take into consideration the principle of equitable balance of interests.
Yes.
Your Excellencies, the Council would like to proceed with the first sub-contention, which is the international obligation. When an accident involving 2 or more ships occurs and the pollution damage results therefrom, the owners of the ship concerned shall be jointly and severally liable for all such damage which is not reasonably separable. The states concerned, this was incorporated in Article 4 of the International Convention on Civil Liability for Oil Pollution and Damage. And further, the states concerned shall cooperate in good faith as necessary to seek assistance from one or more competent international organization in the prevention of significant transboundary harm or any event minimizing thereof. This again is incorporated under the prevention of transboundary harm and hazardous activities. Now, Tistadelphia is being held liable for the breach of its customary obligation to prevent this transboundary harm. It failed to comply with the principle of good neighborliness as the co-agent has already established. And again, looking at the precedents established, in the trial smelter case, Canada was held liable for the pollution. Again, in the Corfu Channel case, the order was given in the favor against the polluters.
That case is applicable to the instant case according to you? Whether it is applicable to the present case on hand?
Your Excellencies, both the case referred to the pollution caused by vessels. However, in the International Court of Justice, there is no authority which is binding. The International Court of Justice can even contradict its own previous judgment. So there is no authority which is binding per se. These are used as persuasive arguments. These are used as persuasive arguments.
Agent, on what basis do you say that we can contradict ourselves?
Take a different stance from what was taken in previous judgments.
So are you saying the principles of precedence don't apply to us?
the precedence of since the International Court of Justice is the
Does the
apex,
principle of precedence apply to us?
It does indeed apply, Your Excellency. However, there is since the International Court of Justice is the apex authority of justice, it has the provision to, in accordance with time and development of laws, change the stance it has previously taken.
Whether it applies to us or not is a specific question asked by my
Answer it in yes or no.
Correct,
Yes.
correct.
Indeed, Your Excellency.
Correct.
It applies.
Yes
or no?
The council
Yes
seeks
for
permission to
apply,
proceed
no
with
for not apply.
indeed, it does apply. Yes, it applies.
All
The
right.
council seeks permission, the agent seeks permission to proceed with the further subcontention, which is the violation of human rights along with water pollution.
No,
Yes,
no, see, as per the fact sheet, where have you agreed to submit in respect of violation of human rights? There are only 3 aspects parties have agreed to.
Indeed, Your Excellency, but along with the environmental damage, there is also a violation of human rights, which is a subcontention or a
No,
consequence.
but you are going beyond the special agreement. You are going beyond the special agreement.
Yeah, indeed. That particular aspect cannot even be dealt here with.
Your
You are
Excellency,
going beyond the special agreement.
Your Excellencies, the agent would like to amend the submissions made and only deal with the water pollution and damage.
For want of amendment, we'll reject this. Is that okay with you?
That is true.
Your Excellency, since the core objective of the suit is not violation of human rights, but rather the core objective of the action being brought forth in front of the International Court of Justice is not actually violation of human rights. It is just a consequence which the agent is putting forth in order to understand the gravity of the situation.
No, we are not going to look at your violation on human rights. I'm sorry, we are not going to look at it.
Indeed, Your Excellency, the council would like to proceed with the further subcontentions.
Yes.
Your Excellency, regarding the water pollution, there has been a blatant disregard for the recognized principles of sustainable development and the general principles of international law as embodied under the Convention on Biological Diversity, as it makes it obligatory under the convention for contracting parties to identify and monitor the categories of activities which is likely to have significant adverse impact on the conservation and sustainable development of biodiversity. The precautionary principle which is laid down which has been recommended by the UNEP Governing Council and also Principle 15 of the Rio Declaration, it states that where there are threats of serious irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent the environmental degradation.
Is Principle 15 ratified by United Nations?
Your Excellency,
or is it specific to European Union?
Your Excellency, the United Nations, under the United Nations Environment Program, the Governing Council has...
Principle 15 you said of Rio Declaration, isn't it?
Indeed, Your Excellency. However,
you are referring to an extension made by the European Union, correct?
Indeed, Your Excellency. However,
whether UN has ratified it or is it confined to European Union only?
Under the UNEP, the Governing Council has recommended it, and by the actions, it can be inferred that that is what is ratified by the UN.
By inference, UN ratifies a convention.
Indeed not, Your Excellency. However, since it is recommended by the UNEP Governing Council, it is prudent to assume that the same needs to be followed by the contracting.
But you have not revealed this. You are quoting this as if it is part of UN documents.
Your Excellency,
only on inquiry you are revealing that it is applicable only to European Union, isn't it?
Your Excellency, I was quoting the Convention on Biological Diversity, which is applicable to all nations.
Okay, you are not relying on Principle 15?
The agent stated that the same principle has also been mentioned under Principle 16 of Rio Declaration. However, the main submission being made is under the Convention of Biological Diversity, Article 7 subclause C and Article 10 of CBD.
Okay.
The precautionary principle lays down that when there are threats of serious and irreversible damage, the lack of full scientific certainty shall not be used as an excuse. And here, Tistadelphia contracted the transportation of the goods in spite of being aware of the increased risk of the carriage of such dangerous substances, which was posed to River Egral and the neighboring countries. Hence, it should not be permitted to be justified on the grounds of the precautionary principle. The agent would like to proceed with the sole use and benefit subconvention.
Yes.
Much obliged, Your Excellencies. The goods carried by the vessels were meant for the sole use and benefit of Philadelphia. The city-state failed to recognize the principles of equitable balance of interest and the international obligations towards its neighbors. Under Article 10 of the draft articles on the prevention of transboundary harm for hazardous activities, there are 6 factors which are enlisted, which should be taken into account to determine the principle of equitable balance of interest.
Again, you are referring to a draft regulation.
Your Excellency, since in the compromise there have not been any any conventions.
No. I want to know whether UN has ratified these. See, we have a limitation to look at UN documents only.
Indeed, Your Excellency.
I could understand you refer to draft state responsibility rules because that has been referred by us before. But these Article 10 that you are referring to is a draft. What is the status of this draft in UN today?
Your Excellency, instead of relying on Article 10 of the prevention of transboundary harm from hazard, the agency an extension of time in the complete the submissions. Your Excellency, the Council would like the agent would like to rely on a different authority, which is the Article 6 on the Convention of the Laws of Non-Navigational Use of International Water.
Please note, you are abandoning your pleadings.
Indeed.
Your Excellency, the distinction here is that the draft Article 10, is based on the principles incorporated in Article 6 of the Convention on the non-navigational use
you
of international
can refer to
waters.
Article 6. That's no difficulty.
Indeed, Your Excellency, but the Article 6 is just a general principle. The factors regarding the same and detailed commentary on the same is provided under the draft draft convention. So the first factor which needs to be looked at is the degree of the risk of significant transboundary harm and the availability of the means to prevent such harm or minimize the risk thereof. Philadelphia did not take any actions in order to minimize the risk. A simple postponement of the carriage of goods would significantly reduce the risk. Since this was not of an immediate or essential, since the goods carried were not of immediate or essential nature, Philadelphia could have considered the interest and the risk involved in carriage of such goods in monsoon. The second factor is the importance of the activity, take into account all its overall advantages of social, economic, and technical character, which again was ignored. The significant harm to the environment and the availability of the means of prevention of harm is the third factor. All the factors which establish that the interest of the neighboring nations as well as allied risks.
Yes, I think you can come to your prayer, because this is beyond. These are all interpretations upon Article 10. I can read that, the draft article. Anyway, you can come to your prayer, please.
If there are no further queries, the agent would like to recite the prayer.
Yes.
Counsel, since there is no particular information as to your signatory or anything of these articles or these aspects, how do you think that, is there any principle that you rely on to say that all of this can be applied to the given matter?
The logic here being, since we are coming to the International Court of Justice, then we are members of the United Nations. And
Indeed.
Again, whatever.
But I'm asking a principle of law which says that all of these can be made applicable. Is there any principle? I'm referring to one particular doctrine. If you give that, probably we'll just speak to my brother judge and maybe even accept your application.
In the Vienna Convention, the ratification and the acceptance of all the UN signatories has been mentioned.
Proceed. Proceed to your prayer.
Much obliged, Your Excellencies. For the reasons stated above, the applicant hereby requests the court to adjudge and declare that the Republic of Wales is liable for the accident on River Egral, that the Kingdom of Rethab is liable for the actions of Rethab Inland Waterways Incorporation, that Philadelphia is liable for the accident caused in the carriage of dangerous substances, and any other relief which the Honorable Court may deem fit in the interest of justice.
What is this any other relief?
Correct, sir.
Okay.
Name it, I'll grant it to you.
Agent, just one question. If we grant you the prayers that you have sought, what is your next step?
There is a convention which is specifically set up in order to clean oil spills. There are member countries which contribute a significant amount of funds for the purpose of oil clean. So we'll be relying on that convention for the cleaning up of the oil spill, and we'll.
No, that's not your prayer.
Indeed, your lordships.
Your prayer is of fixing of liability. We will fix the liabilities as prayed for.
Indeed, once the liability is fixed, the quantum of the damage will be calculated.
Who will calculate that?
By mutual agreement, ideally.
Your prayer cannot be vague. Your prayer should be specific. This is the damages we have quantified. We want so much of amount. This is the amount. How can the court presume? You cannot presume. Prayer should not be, as rightly pointed out by my brother, you should have the specific prayer. Prayer A, B, D, it should be in a specific in the nature. It should not be vague. Afterwards, we quantify, then what we have to grant?
Indeed, Your Excellency, but this matter has been brought forth in order to just determine the liability. There has been no mention of the quantum of the damages.
What my brother is saying is, we will fix the liability. We are granting you what you are asking. What will you do with it? Is there any other body above us who is going to quantify your damages, collect funds, as you say, from other nations to clean this oil?
Who is going to quantify the damages?
As given under the compromise, the damages has already been assessed to be $1.6 billion. So the agent for the applicant would be most humble.
No. That's not damages. That is the loss.
Loss caused.
Indeed, Your Excellency. That is the agent stands correct.
You can conclude. I think you can conclude.
Yes.
Much pleasure.
If your lordships permit, may we proceed with the respondents? Much obliged, your lordships. The respondents may start.
The agent seeks the permission to begin.
Yes.
The agent seeks the permission to address the bench collectively as Your Excellency.
Yes.
Much obliged, Your Excellency. Warm greetings to Your Excellency. May I please this Honorable Court? This is the Council on behalf of the respondent in the case of Union of Remwaf versus Republic of Fail, Kingdom of Rekwa and Testadelphia. I will be addressing issue number 1 and my co-counsel will be addressing issue number 2 as well as 3. I will be taking 12 minutes of the time of the court and my co-counsel will be taking 18 minutes. Your Excellency, the council seeks the permission to address the facts of the case in hand.
No, we are aware of the facts. So please proceed.
Yes.
The council seeks the permission to address issue number 1.
Yes.
The issue number 1 is that whether Fail is liable for the accident of the river Egrel or not. The respondent humbly submits before the International Court of Justice that the Republic of Fail has not violated any of the international law and is not liable for the accident on river Egrel, as the Fail is not liable as the accident was not foreseeable. The defendant will not be liable for the...
One second. Before you commence on merits, I have 2 questions. One is, are you contesting the jurisdiction as agreed in the special agreement?
Your Excellency, we are not...
You're not contesting.
Yes.
You're not contesting, correct?
Yes, Your Excellency.
Okay. Second is, you had reserved the right to raise counter claims. Have you done that?
Yes, Your Excellency. We have done that.
You have raised a counter claim?
Yes.
Oh, now you can proceed on merit.
That the Republic of Fail has allowed the commencement of the journey of the 3 vessels from the Ria, which is the capital city of Republic of Fail, to Testadelphia, after taking the due care and the precautions. Heavy thunderstorms and the possibility of the hurricane are unforeseeable acts for which the Republic of Fail cannot be held liable. Weather changes and the hurricane is considered as an act of God for which no one can be held liable. An act of God is an event which no human foresight can provide against, and for which human prudence is not bound to recognize the possibility.
This is not, Counsel, this is not the act of the God. You ought to have taken precautions in the instant case. Since it was a season of monsoon, you ought to have taken the precaution. This is not act of God.
Thank you for your question, Your Excellency. But in this particular situation, the Republic of Fail has taken proper due care and responsibility before the commencement of the journey. We have looked into all the possible ways and seaworthiness of the vessels.
The radar and the communication channels of the vessel have failed because of the bad weather. Is that not a sufficient cause? Because rain fade is something that you would not incur had your technology been updated to the current standards.
Correct.
Your Excellency, in this particular situation, there is no breach of duty, as the permission for the commencement of the journey to the three vessels is given on 24 January, and the applicant issues a red alert on 26 January after having the accident, which makes it clear that the act is unforeseeable and cannot be expected earlier.
Indeed, communication channels is also one of the particular aspect of seaworthiness.
Correct.
Indeed, Your Excellency, we have looked into all the measures properly. When the vessels are leaving from Riyadh, that is the capital city of the Republic of Fail, we are only at that particular period of time, we are only responsible for that.
So you are accepting that you are responsible for not checking into the communication channels.
No, Your Excellency, we are not accepting that. We are just saying that we have taken due care and negligence for the.
What is that due care in the instant case you have taken? What is that due care? We say that you have not taken care.
According to page 3 of the statement of the agreed facts, it is clearly mentioned that the seaworthiness have been clearly checked by the Republic of Fail earlier before the commencement of the journey.
That is the due care you have taken in the instance case. That is the care you have taken. We say you have not taken any care in the instant case because it was a season of monsoon and you ought to have taken the care. Otherwise, this incident ought not to have happened.
Your Excellency, in there is also one case for which we can refer to at in the Narcos versus Marshall case. It is in that particular case there is the exceptional rainfall which caused the artificial lakes and water flooded. But in that particular case also the respondents were not held liable because the harm is seen that it is not foreseeable, and in that particular case it is held that they are not responsible for that particular act. In the same way,
so was there an exceptional rain in this case? Was there exceptional rain in this case?
The hurricane occurred. That is the main reason for which we are considering act of God. Hurricanes can be considered as an act of God.
No. My brother is asking specific question. Was there rain in the instant case? You referred to the case where there was a rainfall. Correct. And the incident occurred. In the instant case, whether there is a rainfall.
Your Lordship, there is thunder and lightning and rain, which caused the collision.
Yes or no? Yes or no? In the instant case, whether there is a rainfall or no? Specific question asked by my brother. Then how it is applicable to instant case? Next question.
Your Lordship, no, in this particular case, there is no rainfall, but there is thunder and lightning.
Please read your facts. You have named the rain also.
Correct.
There is a rainfall. You have named the rain. Every rainfall it is not named. There is a reason why it is named.
My apologies, Your Lordship.
Go ahead.
Go ahead.
In the another case, that is the Overseas Tankship versus Moot Engineering Company Limited case, an appeal from North-South Waves, the Privy Council has recently held that the defendant is liable only when the consequences of this act has a reasonable man could foresee. Thus, this situation is considered as an act
Council
of God.
Agent, when was this case decided?
Your Lordship, this is the case of 1961.
You say recently it has decided?
My apologies, Your Excellency.
Which court? Which
Which
court has
court? Correct. That was my next question.
In the south,
Which is the
Your
court?
Which is the court?
Your
Thanks.
Excellency, Your Excellency, I would request my researcher to answer this.
No, please read that sentence that you just told us the court. Which council did you refer to?
Privy Council, Your Excellency.
My brother's question is, are we bound by Privy Council judgments?
According to Privy Council judgments are considered as precedents, and
According to?
Privy Council judgments are considered as precedents, and
According to what?
According to what?
According to Article 59 of ICJ, it is clearly mentioned that they are persuasive, they contain the persuasive values, not the authoritative values, and they are advisory in nature.
All right.
May I continue? Your Excellency?
Please continue. Please continue.
According to Article 38, subclause 1 of ICJ, which lists the general principles of the law recognized by civil states as the third source of international law, act of God is considered as a general principle, which is the proper defense which can be used by the respondent in any case where the loss has been occurred due to the unforeseeable act or the...
Can you tell us what are the first two sources, since you say this is the third source?
Your Lordship, first source is customs. First source is, Your Lordship, I would apologies for
Go ahead.
First source is treaty, and another source is custom, and the third source is general principle of law. And fourthly, we will consider the conventions and the treaties.
So statute of ICJ is third source of law.
Yes, general principle of law. Yes, indeed, Your Excellency.
Okay, go ahead.
According to the another act which defines that act of God is the anticipated grave natural disaster or other natural phenomena of an exceptional, inevitable, and irresistant character, the effects of which could not have been prevented or avoided by the exercise of the due care or foresight. Also, there is another case which is cited in point number 9, that the Western and Atlantic Railroad versus Hessler. In that particular case, the court explained the act of God is an catastrophic arising.
Which court has passed this judgment?
U.S. court.
U.S. court. Which U.S. court? Is it the Supreme Court of U.S.?
Your Excellency, I would request to answer this later. The council will be very pleased if you will permit to answer me this question later on.
Okay.
Thank you, Your Excellency. There is also the strict liability of the registered ship owner for the pollution damage caused by the oil that escaped and discharged from this ship. According to Article 356J of the Merchant Shipping Act, it describes the power to give a notice to the owner, that is the owner of the polluting ship. Republic of Fail here is not considered as the owner of the cargo or the one who has
One minute. See, you are quoting authorities after authorities, which are, we don't know what authority. Which law is this Merchant Shipping Act?
Your Excellency, the Merchant Shipping Act is an Indian act, and we are referring to it for the problem.
Then how
But Republic of India is not a party to these proceedings, and it's a municipal law.
how it is binding on International Court of Justice?
We are only stating it for the reference. We are not stating that it is binding.
We say that it will not have persuasive value also before us.
Correct.
Yeah.
My apologies, Your Excellency.
Yes, proceed.
Is there any other international principle which you think could assist you?
Yeah.
According natural principle regarding the VCLT in Article 38, it is clearly mentioned that the third party will be binding on the treaties and the conventions which have been stated, and there are the two international conventions, that is the International Convention of Civil Liability for Oil Pollution
Counsel, yeah, the moment you refer to that article, what it says is if there are treaties or conventions that are signed, it is binding on the parties.
That's all.
In the given case, there is no convention that they have signed. Show me one particular statement in the fact which says that they are signatories to the particular convention that you're referring to.
Your Excellency, there are some of the overriding principles and the fundamental principles of international law which are treated according to the jurisprudence. And in this particular case, we are referring to those international treaties and conventions which are overriding and the fundamental principles of the international law.
Yeah, what is this jurisprudence that you mentioned?
So jurisprudence is basically the compilation of the norms which have been laid down, the international obligations which are essential for the protection of the fundamental interest of international community.
Now this jurisprudence would be overridden by VCLT that you stated, isn't it?
Jurisprudence is an exception of one of the I guess one of the maxim that is.
That's right. That's right. So jurisprudence is corollary to customary rules of international law, correct?
Yes, you are indeed.
Now you are quoting Vienna Convention of Law of Treaties, correct? VCLT.
Indeed, Your Excellency.
Has either party violated VCLT in this case?
Indeed, Your Excellency, we are stating our arguments on the basis of the jurisprudence. As there is no particular law which talks about this, we are stating the basic norms and the fundamental principles which can be helpful for the for giving justice to my.
Okay, go ahead.
Indeed, Your Excellency, that there are the primary rule of the Convention of the International Convention of Civil Liability for Oil Pollution Damage, which makes available that the owner of the ship at the time of incident shall be liable for any pollution damage caused by ship as the result of the incident. According to the CLC 19.
One minute. Owner of the ship will be liable, correct?
Owner of the ship will be the company.
Yes. So according to you, the company is liable.
Correct.
Indeed, Your Excellency.
The company is liable according to you.
Indeed, Your Excellency.
Okay, go ahead.
Your Excellency, I would like to also state the CLC, one of the another 92 convention, which state that the owner of the ship at the incident or the series of the occurrence shall be liable for any pollution damage caused by the ship at the time of the incident. Article 3, Section 4 and 5 of CLC also states that the no pollution claim under this convention, the ground for making the claim against Republic of Wales were considered as baseless, as only the ship owner of the vessels will be liable to pay the compensation to loss which have been made by the explosion of the 3 vessels. As the time is short, I want to conclude issue number 1. Much obliged, Your Lord Excellency. According to various laws which have been stated above, the ship owner will be liable for the accident in River Egrel, and the particular situation is to be considered as an act of God which is not foreseeable. I would request co-counsel to continue if Your Excellencies are satisfied.
No, brother, if you may just allow me, I just have one small question here.
Sorry.
Yeah. Yes. Can you please look at the principle of nationality? Because based on principles of nationality, if a national of any state commits an offense, it is the state which is liable. And you have just before us admitted that the company is liable. So based on the principle of nationality, I think we are to hold you liable for the actions of the corporate entity that you just admitted the liability to.
Your Excellency, I just want to state that on the part of the Republic of Wales, we have taken due care and
that's all accepted. That's all accepted. But what I'm saying is,
Indeed,
on the principle of liability, you are as a state responsible for all the actions of your nationals. So the corporated entity being a national of your country, I think you're liable.
Your Excellency, for the wrong which have done by the company, the state will not be responsible. According that all cases, my co-counsel will elaborate more on this.
Okay, okay.
Much obliged, Your Excellency.
May it please the Honorable Court.
Yes.
This is agent number 2 appearing on behalf of respondents. The agent seeks the permission to address the bench collectively as Your Excellency.
Yes, yes.
Yes.
The agent would be presenting arguments for 2 distinct issues. That is issue number 2 regarding the liability of Kingdom of Rito for the actions of Rito Inland Waterways Fail Inc. Limited, and the issue number 3 regarding the liability of Tista Delphia for the accident caused in the carriage of dangerous substances as stated in the Moot proposition. The agent seeks permission to present the arguments for issue number 2.
Yes.
The respondent would humbly submit before the Honorable International Court of Justice that the Kingdom of Rito is not liable for the actions of Rito Inland Waterways Fail Inc. Limited, as the actions of the corporate entity cannot be extended to a sovereign. The council would like to refer to page number 21 of the memorial, wherein the company Rito Inland Waterways Fail Inc. Corporation owns the vessels, and the company is a separate legal entity from its sovereign, and the sovereign can't be held liable for the acts of its corporate entity. That concept of English common law, the concept has been developed in the case of Oaks versus Sircon and the famous case of Salmon versus Salmon. That the agent would like to place a high reference on Barcelona Traction Light and Power Company case, wherein the court was in the view that the place of incorporation determines the nationality of the legal entity regardless of the nationality of its shareholders. That the landmark case says where the government of Belgium, on behalf of shareholders, took an action in the ICJ. The Spanish argued that if this is a complaint, it was the company's complaint, and the company was incorporated in Canada.
Agent?
Yes.
According to you and your submissions under issue number 2, it is the responsibility of file, correct? And file authorities were negligent. That is your submission?
So along with ship owner, the liability can be extended. As here, the defendants are not having common interest, so they
why don't you listen to me? Just listen to me. My only query to you is, you have expressly stated that file authorities were negligent.
Yes.
Do you agree with this?
Yes.
Counsel, who are you representing?
Who are you representing?
So since we are addressing the issues independently, since we are not blaming each other, but in the defense, it incidentally shifts the liability on other defense.
Correct. So according to you, file authorities were negligent, isn't it?
Yes, sir, I'm coming to that.
No.
They were negligent or not?
Answer
yes,
this.
Sir.
They were negligent.
So that in the vessel, it's structurally fit at the commencement of the voyage.
File authorities were negligent or not?
Not. Yes or no?
Yes, sir.
If file was negligent, that is what the applicant has been pleading.
Indeed.
Correct.
Why
So
to go further?
Yeah, the case has been, I think it can be even adjudicated by now, since you have already accepted it.
Yes. Fairly accepted.
Please see.
Since the agent is representing issue number 2, which is the liability for the Kingdom of Rito, we are defending the Kingdom of Rito.
Yes. Your submission, please go to page 18 and 19. More particularly, page 19 of your submission under issue number 2, paragraph 2.
Yes, sir.
And 3. You have expressly stated file authorities were negligent.
Yes.
If according to you, file authorities were negligent, that is what the applicant has been saying all along. You accept that proposition, correct?
Yes. So, but it's actually saving us oneself only, not blaming others, which it happens.
Counsel, you can split the liability amongst yourself however you want. But right now we are only determining whether you are liable or not. But admitting to negligence ensures that you are liable. So inter se between, your Kingdom of Rita, File, and Tistadelphia, you split the liability however you want.
Among the respondents.
Yes,
Correct.
among the respondents.
Already you have admitted your liability. You admitted you are liable for that. What is the concept?
The council would like to say that it's there is no intention.
Please read paragraph 4 of your issue number 2. Please read it.
Indeed, Your Excellency, the accountability relies on the negligence on the part of authorities at the fail who need to take proper measures because of the seasonal constraints.
That sums up your submission in respect of respond number 1 and 2 and 3, because you are saying those authorities were responsible, not me. That is your submission.
Yes.
And how do you want to proceed?
So the defendants don't have common interest here. So it's not blaming on them. It's just defending ourselves that happens incidentally on the.
You don't have common.
No,
1 minute. Hold on. You don't have common interest. You are all arrayed as respondents. Just try to address this issue, sometime later. You please continue. Please continue.
The council would like to argue for issue number 3, if Your Excellency. Issue number 3, whether the liability of Tistadelphia for accident caused in the carriage of dangerous substances, the respondent would humbly submit before the International Court of Justice that Tistadelphia has not violated the rules and principles of international law, including the conventions, claiming that although the goods carried by the vessels were meant for its sole use and purpose, and due care was taken to appoint an independent entity for safety in transit, and the respondent had no control over the act of exigency. That the act of God defense is commonly thought to be broader in scope than the peril of the sea, and it happens by the direct, immediate, and exclusive operations of the forces of nature, uncontrolled and uninfluenced by the power of man, and without human interventions, and is of such a character that it could not have been prevented or escaped by any amount of foresight, prudence, or any reasonable degree of care or diligence. The council would like to refer to the case of Stone Oil case, where the Judge Lemon held that hurricanes are considered as a matter of law to be an act of God and is defensible. That also under the case of the Boneslaw-Colsbury case, Justice Brandon J. Said that the standard of care to be applied by
Hold on. Agent, this Stone Oil case, which court decided this?
So I'll get back to this question
All
after
right.
the submission.
The current case law that you are quoting, that is the next case law. Tell me which court decided it. The Bones Law case.
Which court?
Counsel, the general observation is everyone has been evading the questions that is posed by the judges. I think this is not how you should take your interest of the client, no?
And they quote authority after authority without even knowing where that authority is flowing from.
Correct.
Are you aware which court is this or not?
No.
So I'm not sure about.
All right. Go to the next paragraph, next case. Tell me which court.
How can you cite the case law without knowing the court? Which court decided it?
It's US court.
Which one?
Which court?
I'm talking about the Octavian vessel case. That was your third case, no?
Yes, sir.
Tell me which court decided this. Are you aware? Are you not aware? Let's move on.
I'm not sure about
Yes, yes, yes. Proceed.
Please go ahead.
The council would like to state that as per the Act of God, which was earlier described by the US Supreme Court in the Majestic, that the Act of God said means inevitable accident without the intervention of man and public enemies, and again that happened by the intervention which do not happen by the intervention of man, nor are to be prevented by human prudence. That also
this was held by a US court, correct?
Yes.
Now go to the next case. Which court decided the Riveria case?
I'm not sure about.
There are 5 judgments you have quoted to persuade us without knowing which court has passed these judgments, except for one case which is passed by a US court. Okay, go ahead.
The agent would like to state that the Philadelphia being a cargo owner cannot be extended to a liability, since under the CLC Convention of 1992, it puts the liability only on the ship owner and prohibits claim against the servants or agents of the ship owner, members and crew, also who carrying out the salvage and taking preventary measures. Also, there is no liability mentioned till now under the international law for extending it to the cargo owner. Also, under the Admiralty laws of the US has always as shown given the cargo owner full protection against the losses in collisions. The cargo owner has been regarded as innocent. So, as per this,
again, cargo owner has been regarded as innocent under which law?
So, under the Admiralty law of the US. Also, again, of the US, the Oil Protection Act of 1990, which originally had a provision which made the owner of the oil liable for
Protection Act of US.
Yes.
Then another law you quoted of US. This is not a US court. See, there has to be some jurisprudence submission on these things. No, how do you bring these authorities in this court? And you are asking us to look at authorities which we are not bound to look at.
But sir, the case is upon based upon use cogence.
No. Just because US court has passed the orders,
it does not become use cogence.
On us. Those orders are not binding.
See, use cogence means something which is an erga omnes obligation.
Correct.
Unless it is being held to be erga omnes obligation, merely because it's decided by other countries does not make it use cogence.
Correct, sir. Correct.
So it's the belief that the civilized nations follow the international.
It is your belief that civilized nations follow US.
No, yes. So it's not our belief. It's the principle stated in the international law.
We say we will not follow the law laid down by the US courts. We will not follow.
The agent, please understand the query from the court regarding the courts has a semblance because there are customary rules of international law through which you can introduce judgments passed in municipal laws. That is the reason why we have been asking. If you rely on that principle, except for saying use cogence doesn't mean that you can quote judgments of municipal law in an international court. All right. What we wanted to know was whether you are relying on a celebrated principle of customary international law under which you can quote judgments of municipal laws. Go ahead.
So under the opinio juris, the state, the practice of the state is due to the belief that they are legally binding by the rules.
Very well. Go ahead.
Yes, go ahead.
The council would like to conclude that respondent number 1, that Philadelphia is not liable as the act was beyond the control, and the cargo owner's liability has not been extended beyond, and it's only the ship owner who is liable under the 1992 Civil Liability Convention under the strict liability. The council would like to present the prayer.
Yes.
In the light of issues raised, arguments advanced, and authorities cited, the Council for Respondents humbly pray for before this honorable court to kindly adjudge and declare that respondents did not violate any international environmental obligations and that respondents number 1 and 2 acted in due diligence, 1 and 3 acted in due diligence, but the accident was not foreseeable, and that respondent 2 being sovereign will not be liable for the actions of corporate entity and pass any other appropriate order that would be deemed
I
fit.
think my brother judge and I are very eager to stop you at here because you've clearly not used the sovereign principle in any of your submissions. Second to it, you have made a clear statement that respondent number 2 has been negligent and because of which it is liable.
No,
And then
sir, we
how are you
have
asking
not
for a
made the
quantitative
respondent 2 negligible.
One.
We have said
File authority.
File. Respondent number 1.
sir, it's in a defense.
Okay. Now tell me something. You have an elaborate prayer, right? 1, 2, 3. We will not grant all this. We'll just reject the application. You'll be okay with that?
No, sir.
And
No.
one more question was asked by Kamath sir, our brother judge. Your agent number 1 told my counsel will argue so far as liability is concerned. It was a specific
nationality.
Principle of nationalism. So you are liable. Your co-agent told my agent number 2 will answer that. Please answer that and elaborate.
Sir, according to the Barcelona traction case, we are trying to shift the liability from Kingdom of Rito as the company was not incorporated or does not have any business operation or does not have any backing investment from Kingdom of Rito. So if
but brother, it is very strange that I asked them, we'll reject the application. They don't want rejection. They want specific order as a respondent. Prayer number 1, 2, 3 should be granted.
Rejection will suffice the purpose. It is sufficient. No?
But they don't want that. Would you be okay if we reject the application straight away?
Sufficient, no, counsel? Agent, we will reject that. That will not suffice the purpose. That is not sufficient for you.
No, sir.
Then what is your prayer? Next prayer. Kindly read the prayer.
Please read it again.
So we are trying to shift the liability on the ship owner, that Waterway Fail Inc. Limited, and since the company is bankrupt,
please read the prayer.
Read the prayer.
That the respondent did not violate any international environment obligations. That respondent 1 and 3 acted in due diligence, but the accident was not foreseeable, and that respondent 2 being sovereign will not be liable for the actions of corporate entity.
The order of rejection is sufficient or not. We will reject the application or case made out by the...
On merit, we'll reject. We'll reject on merit.
We will reject on merit. We will pass a comprehensive order.
But we'll not grant you your prayer 1, 2, and 3. Is that okay with you?
You have not approached us. They have approached, we will reject. You will succeed in this case.
And also, I must tell you, agent, I had inquired at your commencement to your co-agent that you had raised some counterclaims. There are no submissions on that.
There are no counterclaims.
Correct, sir. Correct.
We have counterclaimed on Act of God. We have also a counterclaim on the polluter play principle, which makes wherein the cost of...
No.
Counsel,
please hear Justice Kamath. Please hear him.
Yeah. You'll have to brush up on your fundamentals clearly, counsel. Probably, I think that is one of the small drawbacks that is there.
Defense cannot be counterclaim.
Yeah. So counterclaim is generally raised against the opposite party who has raised a claim against you, and you all being co-respondents, I think probably you must have made it clear in your title of the suit as well, or your petition that you filed here. You have not mentioned the difference between the parties, so you have not altered any of it.
Whisper about counterclaims.
Yeah.
Correct. So specific question was asked whether you have claimed.
So I think agent number 1 was trying to mislead us, is it?
The agent want to apologize.
No, that's okay.
Also, sir, the answer to the case
on nationality.
Court, court case is that the Bonsla Colsbury is the US Supreme Court case.
All of them are US.
Yes,
All of them
sir.
are US.
I know.
Agent is also from US.
Yes, all the cases are from US.
Very well.
Fine.
All right.
Counsel, good effort, but please
Good effort. Good.
work on
Much
it.
obliged, Your Excellency. It was
Yes,
a
yes.
pleasure to argue.
Any
Yes.
rebuttals?
Indeed, Your Excellency, the agency seeks
Yes.
permission to proceed. with the
You have 1 minute.
Indeed, Your Excellency.
You reserved 2 minutes, but we had granted you more time. So you have consumed that. You have 1 minute. Okay.
Indeed, Your Excellency. The respondents have been time again shifting the blame from one party to the other in order to evade liability. This cannot be done. And as answering to the queries earlier posed by Your Excellency, the corporate will was pierced in the same case cited by the respondents, which is the Belgian government case.
No. See, listen. You are not aware. Are you aware of the facts of the case?
The agent briefly went through the case, Your Excellency.
The lifting of corporate veil query was posed to you, not to them.
Indeed, Your Excellency. In order to answer that,
you are quoting a case law quoted by them without knowing the case.
Your Excellency, however, the shareholders of Belgium were the corporate will was pierced in order to recognize the national shareholders. That is the principle which the agent is.
All right. Okay. What is your next?
That's it. The agent rests.
All right.
Any rebuttals?
The agent would like to again state that the case of the Barcelona traction case wherein the nationality is not shifted to Kingdom of Rito and ship owner will be liable. It's the company's case.
All right. Okay. Court officer, they can stop now. Okay.
Your Lordships, may we conclude?
Yes, please.
Yes.
Much obliged, Your Lordships.
Yeah, one second. What is
Yes,
it?
Your Lordship.
Okay, can we get feedback, sir?
No, not at this stage. You can approach the court officer to approach the judges offline because we have another round. We don't want to conclude because the other members are watching us. All right. This may be not a right time to give you feedback. Although we would love to, as lawyers, we love to talk, but not right now. Okay.
Thank you,
Yes.
sir.
Participants may now exit the meeting. Thank you.
Should we join some breakout room or something?
No, but I just wanted to understand.
So I think it's still on live streaming.
Yes,
Yeah,
Yes,
yes.
Your Lordship, just a minute. We'll put you in
Yeah,
the
because the audience also need to exit, I believe, for a minute.
Yeah.
Yes, sir. That is true.
you in the breakout room.
ಮಳೆ ಹೆಂಗೈತ್ರಿ ಅಣ್ಣ?
ಬಾಳ ಐತ್ರಿ. ನಿನ್ನೆ ಇವತ್ತ ಕಡಿಮೆ ಐತಿ. ನಿಮ್ಮಲ್ಲಿ ಹೆಂಗೈತಿ? ನಿಮ್ಮಲ್ಲಿ
ಸಿಕ್ಕಾಪಟ್ಟೆ ಮಳೆ ಐತಿ. I came on a holiday to Lonavala.
ಹೌದ್ರಿ?
I'm stuck in the room. Kishu, give me the phone 1 second. Kishu, give me the phone 1 second. I just want to check what is it. Now, Court Hall 1 is inviting me to join. What is this? Rohit, you're on mute.
Yes, sir. So that's a breakout room. So I think you'll have to press join so that we can join in there.